We want to be respectful of everyone's time and finish on time, so let's get started. Good morning or afternoon. I'm Tanya Canal. I am, along with Alice Adam, the co-chair of the Houston Bar Association Elder Law Committee. And we want to welcome all of you here today to the orientation for the Will-a-thon. Thank you for your time today and for your commitment to serve seniors and veterans through the Will-a-thon. I won't stay up here long. I will give you guys the current information regarding the Will-a-thon. As of today, there are 208 clients who are registered and about 100 lawyers, which I've been assured in the past has worked. But of course, they're going to continue to take calls and continue to do intake even after that April 8th date that was originally announced. So if you have an opportunity to pass on information about the Will-a-thon, HVLP will still take people's calls. And of course, they'll still take lawyer volunteers to sign up. Today, we have with us from the Houston Volunteer Lawyers Program, Alissa Rubin, who's the Executive Director, Michael Hofrichter, whom you'll hear more from today, and Veronica Jacobs, who's in the back. And then from the HVA, we have Ashley Steininger and Jessica Lindsay. And I think they're both still outside helping people. So without further ado, I'm going to turn it over to Alissa. And thank you again for being here.
Great. Thank you all for coming and for volunteering. Before I start, how many of you have done the Will-a-thon before? Okay. Veronica, you don't count. So this is fairly new to most of you, and let me help walk you through what to expect and sort of how we got here, 208 clients and counting. At each of your seats are some information. There's a volunteer guide. This is Houston Volunteer Lawyers, more general information all about HVL, how we qualify clients, with whom we work in the community, how you can find pro bono opportunities, and more, and contact information. And within that, you have an agenda for today's training, and then 2 flyers. One is what I'll walk you through briefly here that has Houston Volunteer Lawyers logo at the top. And the other is a flyer for our next big CLE event, which happens to be an opera performance by Houston Grand Opera, May 3rd and 4th. It will get you an hour of ethics credit, and buying a ticket, the proceeds get donated back to Houston Volunteer Lawyers. It will be at the 1910 Courthouse. The Houston Grand Opera is performing this in partnership with the Houston Bar Association, Communities and Schools, and Baker Botts. And it tells the story of Houston's first pro bono case, an 1847 case by the man who founded Baker Botts and who went on to be the first president of what is now the Bar Association. He freed a slave with a jury of 6 white men in 1847. And so the opera made a performance out of it. The actual opera is only about 45 minutes. And then there are hors d'oeuvres before and coffee and dessert after, and a chance to speak with the cast and the judges who found all these wonderful documents in the district court archives, which is how we discovered it. So consider doing that as your next ethics credit and chance to network. But let's get back to the Will-a-thon. And this sheet right here kind of has an outline of what to expect. So our Will-a-thon, which the Elder Law Committee of the Houston Bar Association has been spearheading for the last 15 years, is a 2-day Will-a-thon. So on the first day, you meet with a client. You essentially will come out to the Tidwell Park Community Center, and we'll give you a little bit of instructions on how to get to the actual building we're in. And when you arrive, we're essentially going to match you with a client. We will give you everything you need on site, all the paperwork, the questionnaires, the documents you need to fill out. And I'll go over this again in just a second. But essentially, on day 1, you're meeting with the client and interviewing them and finding out their wishes for how to complete all the documents that Michael's going to walk you through today. So you will leave there with a questionnaire we have prepared that you will fill in. plus any of your own notes, to determine what the client wants for their will, for their medical directives, etc., so that when you leave, you have everything you need to draft the documents, for which we provide forms online, and we'll show you where to find those. And then you come back on the second day in May to execute the documents with your client. We provide the witnesses, the notaries, translators. You show up, and your client shows up too at a assigned appointment time that we'll give them at day 1. And when you're finished on day 2, we have scanners that I'll talk about how we're going to use them on both days. And when you leave, the clients, we will scan all the documents. The clients will leave with the originals, and that's that. You'll be able to access those files through our portal, and we will all forever have a copy. The client will need nothing else after day 2. So it's a really nifty sort of package deal for clients and for volunteers. And the reason this has been going on for 15 years is I think the clients are extremely grateful and really enjoy this service. So thank you again for volunteering. So a little more specifics, and then I'll give it to Michael Hofrichter to walk you through the actual forms and documents and what this is talking about. But on day 1, when you show up, we will, like I said, pair you with a client. The clients have been scheduled for various time slots, and so they'll be coming in waves, and so it's a pretty well-run machine. So when they come in and we match you with someone, you will sit down with them at a table. It's in a big gym, and so there's lots of tables that look just like this, and lots of mini conferences going on between lawyers and clients. We will have translators there. There definitely will be some Spanish speakers. Don't be alarmed by that. We'll talk to you about it before if that's not something you're willing to do. But when you meet with the client, we will give you a red folder that has in it a questionnaire and information about the client that we've previously collected. You will interview the client and go through that questionnaire and get what you need to draft the documents. But before you leave that day, we need you to, and this will all be set out in the room and obvious in tables, and we'll remind you, but just so you have an idea of the flow. There will be a table with scanners, and we'll have you and the client go up to that table, and we will scan a copy of what you filled out so that if you lose it after day 1, you can get it on our portal, your own notes. Our portal, which Michael's going to demonstrate, is it's an extremely robust and powerful tool. It is very, very secure, and so you can only see documents and information for your client that we link you to, and so that's what you'll be able to access via the portal, not really anybody else's, but yours and your clients. And that day we'll have you sign what's effectively an engagement agreement with the client, and another little form we need to take with us so we know to link you to that particular client, since we're not matching you up until the day of. So long story short, there's just a couple of documents to sign, a professional services agreement, and what we call our initial disposition form saying you will be the lawyer for this case. And then we're going to scan all that for ourselves. You leave with all the notes, the client information that you need. When you get back to your office, you're going to have about a month to draft the documents that the client desires. And we will provide you options for a bunch of different forms in what we call our estate planning packet. So it's not just the will, but things like a HIPAA release for someone that they wish to be able to have access to health information as someone ages, for example. They may not want all of those documents, but the ones that they opt to have, you will have time to draft. We make all of those forms available on the portal. They're in Word, they're in annotated format, so you should be able to just pull them down and essentially fill them in and customize them to your client's circumstances. Then we really encourage you to stay in contact with your client and be able to give them a draft before that second day of execution so that no changes need to be made. It's not okay to make handwritten changes to things like a will, and so you really have to have it in final format before you get there. That still may happen, and if it does, our offices are in this building, and we're happy to help you finalize the execution of documents with your client at a later date if something comes up, but you want to try to avoid that. And so when you come to day 2, hopefully you and the client have agreed that everything looks like they wanted, and you show up at an appointment time we'll give you at the close of day 1, and we'll sign the documents using scripts that we will provide that are appropriate under the Texas Estates Code, and we will have the witnesses and notaries and translators that you need, and then scan the documents and give them back to the client, and you're done. Questions about sort of the broad overview?
Yeah, I have 2 questions. One of them is, I understand there's a way to pair lawyers if a lawyer's not going to be able to be here for both sessions. How does that work?
That's not difficult at all. You just tell us at the end of day 1, and we'll keep that slot for someone else to do the execution.
Oh, okay. So it's not like they have to be together for the making of it.
It's ideal, but no, we got it covered.
And my other question is, I live in Austin now and would be interested in seeing if Austin Bar Association would be interested in doing something like this. Are these documents developed by you guys, or are they?
These documents are generated really from, they're Houston Volunteer Lawyers specific. They have a little bit of, I think, Harris County maybe specific nuances, but for the most part, they're Texas standard forms. And Volunteer Legal Services in Austin is our equivalent there, VLS, and they do some stuff like this.
Okay, thank you.
I can put you in touch with them if you want to know. They're a great organization.
To the extent we need a translator, will we have translators available to us throughout the month?
Yes. So Houston Volunteer Lawyers, you can thank your state bar dues for this. It's so fantastic. I don't have enough enthusiastic words to really just tell you how great this program is. But a few years ago, the legal services organizations around the state were really struggling with ESL clients of all kinds of languages, and it was just cost prohibitive for us to provide translators to volunteers, and then it was obviously a barrier for volunteers to take those cases, and so these people who speak another language were just falling off our waiting list right and left, and we were just very bummed about it, and found out that it was not only a Houston problem but statewide. And so the state bar took a look, and long story short, they set up a fund that's called the Language Access Fund, and they did a pilot 2 years ago to see if anyone would spend it, and long story short, it got depleted very quickly, and it's now a permanent fund, and what it does is provides to Texas Access to Justice Foundation funded organizations. So Houston Volunteer Lawyers, VLS, some of the major players in the state who receive access to justice funding. We have access and can pass it on to our volunteers and do to translators in any language available on 1-800 number at any time. And so all you need is a 3-digit code that we automatically give you if you take a case from us that's for a client who speaks a language other than English. You can request literally any language. And so when you have a client in your office or on the phone, you can 3-way call, you can use it on speakerphone. They do document translation as well. And they, not for this purpose, but they also do in-court interpretation. So it's all completely free as long as your case is through Houston Volunteer Lawyers Pro Bono. So don't let that be a barrier. Don't get, I mean, it is definitely a little bit of extra time, but it's not much, and often those are the neediest of our clients.
How do you handle husband and wife? I notice here that you can't have them in the same room at the same time, which is a great idea, but how is that 2 separate clients then?
2 separate clients, 2 separate lawyers.
Oh, okay, good.
We basically just don't assume they're going to leave stuff to each other.
Are there any challenges exchanging drafts, and I presume that you do that electronically?
What do you mean, with
Like
us?
email?
I think it's fine.
I mean, so all the people that attend, in other words, will have email.
Oh, that's on a case-by-case basis. A lot of them may not. Veronica and Michael can probably comment more, but I think it just depends. Many do not. Some will say, well, you can send it to my son's email address. You want to caution them, obviously, that could be a privilege issue. So I think explore that. We get that information on our application. But generally, I would assume that, you know, low-income seniors have an email address that they're comfortable using. And so often, you know, you can ask them to come to your office or meet at Houston Volunteer Lawyers office or go to them or meet somewhere neutral or exchange by mail. Any other suggestions, Veronica or Michael, on that?
If not at your office, the office can be at a library that's in their neighborhood, because sometimes they have problems navigating, particularly downtown or in areas that are too far away from their homes.
That's a great idea. Okay. If no more questions, I'll give this to Michael to talk about more specifics and actually demo what I was talking about on the portal. And by the way, if you're not comfortable using the portal or email, just call us and we'll send you the forms.
Thanks, everyone. All right, so I'm going to take the schedule a little out of order to discuss something to discuss interviewing your client, and then I'll go on to the portal and the forms themselves, so this way all the computer stuff is together at the end. In terms of interviewing your clients, basically the room setup, we've got 2 rooms. There's a orientation room, reception room for the attorneys, and then down a pathway, we've got a very large gym that'll be set up with 30, 35 tables for you to interview your clients. When you're interviewing your clients, at that table, it should be you and the client. There may be a need for a translator. Most of our clients right now scheduled are English speaking. We do have a number of Spanish speaking clients. Do we have volunteers who speak Spanish here? A couple? Any speak Russian? French? Okay. So I know we've got at least one client who speaks Russian, one client who speaks French. And we'll make arrangements to use the translation services when we don't have an in-person translator available. We've got, as Tanya said, about 200, a little over 200 clients scheduled. They're scheduled for every half hour. So feel free to take a look at the questionnaire in advance. Take a look at the questionnaires have been sent to all the clients. They may have been able to fill it out on their own. They may have filled it out with a child helping them. So make sure you go over it. Make sure that the questionnaire says what they want, not what their youngest daughter wants mom to do. So that's always a big concern. When you're at the table, make sure that it's just them and not the kid who brought them who's there. We have had a number of instances where it's the children who are pushing mom to get estate planning documents. And as you'll notice on the forms, we don't do a durable power of attorney. We don't do a financial. And that's because you guys are meeting the client for half an hour. The elder law committee made the decision, let's hold off on that and save it for instances where you've got a more lasting attorney-client relationship with the client, and you can really assess that there's not going to be any potential abuse by the agent of that power of attorney. So make sure that when you're going through the questionnaire with them, that it's, as I said, their wishes, that they understand what's going on. We're drafting the will. Most of the clients are seniors. There are some people who are veterans who do have minor children. Not the majority of clients, but there are some of those. So there will be instances where you're talking about, well, what do you want to do if in the case of a minor child? Beyond the will, there's the medical power of attorney, the directive to physicians, the HIPAA release, the declaration of guardian in the event of need, and the agent to control disposition of remains. Actually, I think they've renamed that form and it's a little simpler. But those are the forms that will be drafted initially based on the questionnaire and to go from there. When you're doing the drafting, we ask if you've met the client on the first day of the event. If at all possible, you can make the drafts yourself. So that you've met the client, you've got a better sense of what they want, than anyone who's just going to look at a questionnaire. And you get a lot of information from the questionnaire, but it's that nuance of, oh, I really thought that this is the direction that they wanted to take the will, that it's really going to be to my grandchildren for Sturpees or whatever, that additional detail is something that's going to be present from your interview that may not immediately be conveyed in that, that questionnaire. So if you're doing that initial interview, please draft the documents. If you've got questions, I know every year I review at least 10 or 15 different wills from attorneys who have drafted them for the Will-a-thon. I know Veronica probably sees at least the same number, if not more. So we're happy to review them. We're happy to give you comments and feedback and double check for mistakes. Just know that if you're going to ask us to do that, you give us a little bit of lead time. The day before the execution date, we get a little busy and we may not be able to review them. At the execution itself, we've got scanners. We have limited computers. So if you think that there might be an issue, please bring your drafts on a flash drive. And I know last year we had a couple people and we were able to print out changes where a name was misspelled or something like that. But again, that only is possible if you've got them on a flash drive, and we can go from there. Yes?
Will there be Wi-Fi? Can we bring our laptops?
I don't know if there will be Wi-Fi.
Staff is there right now, actually, so I'm going to
No, tomorrow.
Oh, tomorrow.
Tomorrow. Yeah, so we can ask tomorrow when we're there. I don't know if there is or not. So it all just depends. Okay. All right, let me go ahead and demo the portal, and we can walk through the forms together. Okay, so our portal is located at portal.makejusticehappen.org. This is the, you can also get to it from our website, makejusticehappen.org, and there's links to take a case, there's links at the bottom of the page to the portal, but this is our portal. If you've volunteered with us before, how many people have registered on the portal and used the portal? All right, how many people have taken a case from Houston Volunteer Lawyers in the past? All right, so if you've not registered but you've taken a case, right, all you need to log into our portal is to create a username. So you click here and just use your bar number and your bar number and your name to create a username. And then you get the option to create a username and finish the registration. If you've never registered with us before, there's the second registration link. And this asks you to fill out your contact information, your bar number, your hourly fee, that sort of information, so that we can contact you and we can add you to our system. Once you submit a registration on this side, it'll take a day or two. Our staff then checks that you are actually licensed and then approves your registration, and then we send you a link to that first one where you use your bar number, your first name, your last name to create a username. Once you've done that, you can log in. Right? And the nice thing is there's all sorts of resources. So at the bottom of the page, there's the volunteer resource manual. That's this. So if you lose this, you can get a copy of it. And then on the top, you can do everything from search waiting cases, view your open cases. So the benefit of viewing your open cases is once you've been linked to the client, you can click here, you can add time, you can add notes, etc. Your closed cases. This is a feature we added specifically for the Will-a-thon. After the execution, we will upload copies of the executed documents to the client and then close the file in our records. Under the closed cases, if you need to download a copy of those scans, whether it's for having your own copy in your office of the documents that you prepared, or whether you told the client you'll send them 3 extra copies of their medical power of attorney for them to give to their doctors, this is where you can get those documents. Account profile, clearly. But then estate planning resources for Will-a-thons, this is the key set of resources for the HBA Will-a-thon. Note at the bottom is the language line instructions that Alissa mentioned earlier. So if you need to talk to a non-English speaking client, that's the way to do it. Each of these documents that are up here are annotated. I and a couple of the other staff attorneys have gone through them and made a lot of notes in terms of what to expect, some drafting suggestions, when you might want to delete a paragraph, when you might use this paragraph versus the next one, that sort of thing. It's all done in Word. They're all done as comments on the side. And text that's in the body of the thing that's options are typically in brackets. So you can go through and you can go ahead and do a Control F to find an open bracket, a closed bracket, etc. So just to make sure that I was going to have Wi-Fi and be able to do this, I've already downloaded all of these documents, so I'm going to skip over to that. So the estate planning questionnaire that we use for the Will-a-thon was drafted last year by the Elder Law Committee. And it's bilingual with Spanish as a sort of subtext on the forms. And we have a secondary version of it that has English as the secondary language on it. Once it opens. But this basically goes through, it asks for family, so that you've got a sense of who their family members are. It asks about assets. It asks about disposition of those assets. Sorry, this is taking extra time. I was opening the questionnaire. All right, so while that thinks about opening, let me go over the will with you guys. So as you can see, it's in Word with all of the comments on the right. One thing I've gotten in the past is when you go to print, by default, those comments will print. So there's 2 ways to avoid that. One is if you go to review, you can change this here from final, show markup, to just final. Or under comments, you can just turn off comments, and then, or you can just delete each comment. And there is a way to delete all comments. I just don't remember what the key combination is for that. But it's useful to highlight places where you might have stumbling blocks. So to start with, in the with the will, the first thing to note is that the first sentence can be tricky. The first sentence typically says being of sound mind and body, or something like that. We've all heard that phrasing. We've always removed, or recently, we've always removed sound body from that sentence because their health is irrelevant to whether they can make a will. It's really about their mental capacity and whether they're able to do that. And do they know their children, their descendants? Do they know what property they've got, what they're leaving, what this is disposing of? And if they do, then it's they're pretty good for the most part. Remember that making a will requires less testamentary, like in terms of mental capacity, the need is less than that for a contract. So if you've got an elderly client whose memory is slipping, they might not be able to execute the powers of attorney, but they can execute a will if they've got an idea of who their kids are, who their family is. And if you've got questions, feel free to ask the staff attorneys who are there, feel free to ask the HBA mentors who are there. We've all experienced this in the past with other clients as well. In terms of the will, we're also looking at family, right? Who is members of the family? Remember that if the client is considering a divorce, that a divorce will affect an existing will by removing any mention of the spouse as though they predeceased. Right? That's the legal effect of divorce. On a will is that it basically says treat the ex-spouse as though they predeceased me. And so if the property was to go to the spouse and then the kids, it just goes straight to the kids. If the spouse was to be the executor, you automatically look to the alternate executor. So if they're considering a divorce, make sure that they're aware of this. If they are not considering a divorce, it's not as important. If they've already been divorced, it's a good reason to get a new will, because then you can make sure that even, let's say you're divorced, but you're still on good terms with your ex, and you want them to be the executor, you've got to reapprove that and reauthorize that. There's language here about having a child born after the will. Most of our clients are going to be elderly. That's not as important. But it's there because we use these for all of our clients. At the bottom of every page, we've got an initial line. Make sure that when you're doing the execution, you've got your client initialing every page. A lot of attorneys will also ask the witnesses to also initial every page. This is so that you can say all of these pages of the document were at the execution together with the same people seeing every page. This is the same reason why when we're doing this, we ask you not to staple the will, right? Because once you've finished the will and you've executed it all, we're scanning it, and then we'll staple it. With a will, we can't unstaple it. And my father ran into this as when he was drafting his grandfather's will. He drafted it, and then my great-grandfather unstapled it, and then restapled it, and then unstapled it, and then restapled it when he was making copies. And the end result was that when my great-grandfather died, my father then had to go to court and had to pull out the carbon copies of the original draft, and you can see how this is a little dated, but had to pull out the carbon copies of the original draft to say these were the same pages that were present when I drafted the will. These are the same pages that existed, because what happened is that the judge saw all these staples and all these staple holes at the top of the will and said, all right, well, prove to me that this is the will as he signed it, and that these staple holes are not because someone took out a page and put in a new page. So to prevent those issues, we've asked, don't staple it until we've scanned it, and then once we've scanned it, we'll staple it, we'll give it to the client, and we'll tell the client, don't unstaple it. If you need copies, just fold back that corner. But that's because having these initials on every page helps to say this page was present at that execution. All right, we've got language in here in terms of this section here is all about the disposition of the estate. so we've given you sample language for a whole bunch of different scenarios. I give, devise, and bequeath blank to blank. So just your outright gifts of a specific item of property. The other thing is we've given you a residuary clause that says I give everything to my husband or wife, and if my husband or wife doesn't survive me, then to my children. So that's fairly typical. Some of our clients will say that they want to give it to their spouse and then their grandkids, or their children and then their grandkids, ignoring their spouse. Just be aware, this is the fun part of estate planning, is making this work. Because clients will come up with all sorts of interesting combinations that they like to try. So make sure that they have a good sense of what's going on. At the same time, you want to know what property they've got. If they've got a house that they're living in, they probably want to give it first to their other spouse and keep it intact. Or they probably will say, well, let's give it to my grandkids. Well, when you've got 5 grandkids who live in different parts of the country, that may not be the most sense. And then if you want the house to stay in the family, you've got to figure out, well, who's going to want to live in this house? So there's some additional questions that you're going to want to ask when you know what sort of property they've got. At the bottom here, optional paragraph D is a written memo about the disposition of specific property. So this is, I know my grandfather had one of these sheets where you kind of lay out, oh, I'd like it if my grandson could get this car, my daughter got this painting, etc. The small bequests that might not be readily evident when you did the major will estate planning, but things that the client might want to update in the future. Those are available, and you can just make a short one-page document saying, I give this to this, I want so-and-so to take this. The thing is, it's not binding because it wasn't created at the time of the will. It wasn't created before the time of the will. So it's not incorporated by reference into the will, but you can still have that little, I want to make sure that this little thing gets to so-and-so, this thing gets to so-and-so, and then the executor can take it into advisement, but they don't actually have to honor it. So it saves them from having to redo a whole will if there's not going to be a will contest. If you think that if your sense of the impression is that there's going to be a contest, that there's going to be kids wanting to fight over things, then this is probably not helpful. But if everyone's pretty amicable and you're saying, well, someone, like Johnny really likes this painting, make sure he gets it. And Rose really enjoys the silverware that I've got, she should get that. It's a nice way to say, I think that this is the direction that the property should go. The caveat, make sure if you tell your client about this and they use this, make sure they date these. My grandfather had 4 or 5 of them when he died. None of them were dated. So knowing which one was the last one was really a question of which property was he mentioning that he still actually had. Like the car that was destroyed in the hurricane, we can ignore that one. So know about it, be aware about it. It doesn't work in every case. The last paragraph is a Uniform Gifts to Minors Act. So that's if you're giving money to a minor, it puts it in a protected account so that it's reserved for the minor, it's specifically, those accounts are really for money or stock or that sort of thing. If there's that, and if they're going to a minor, that paragraph's relevant. The next section here is a contingent trust. This is, again, if you have got minors. minor children, minor grandchildren who might be inheriting. You want to make sure that if you're leaving to a child, that it's being left to that child appropriately. So again, this is where you can have fun drafting. Some attorneys or some clients will say, look, the kid should get everything when they turn 18. Or the kid should get 25% when they turn 18 and the rest when they turn 25. The language is here to play with it. You can also, there's also language here that says that the property can be used to benefit their health, education, etc. So if you've got the trust can pay for private school, or the trust can pay for college without having to be distributed to the child completely. One thing to note, if you're appointing a trustee, and let's say it's to wife and kids, right? Don't appoint the wife as the trustee. Does anyone understand why?
Conflicts of interest.
No. So if you're saying that the property goes to the wife then the kids, then if the property is going to the kids and you're using the trust, the wife is dead. So the wife can't be the trustee. Just make sure you've thought that through with the client and say, look, who do you trust to be the trustee? And if there's no one that they trust to be the trustee, then you've got other questions. And maybe this isn't the right vehicle. But be aware of it. With the trustee, none of our clients are going to have large enough estates that you could have a corporate trustee, right? The corporate trustee says we need a minimum estate of $50,000 or whatever the limit is before we'll be able to do it. None of our clients are going to have that sort of an estate. So there's a whole bunch of language there, again, talking about the trustee powers. If you're not doing a trust for a client, take all these paragraphs out. You don't need them. So for a lot of our clients at the Will-a-thon, you can, any of these paragraphs that say remove if no trust in the notes, you can go ahead and remove. In terms of compensation or bond, those are issues that you can discuss with the client. A lot of times if you're dealing with a family member who's taking charge of this trust, you probably don't want the trust to be depleted by paying the trustee's fees instead. So be aware of that. You can appoint guardians in the will. In terms of saying, I want so-and-so to be the guardian of the child. This is an expression of desire. It is not a immediately binding effect. Guardians still have to be appointed by the court. Or custody has to be established by the family courts. But this is a way where parents can express their wishes in terms of who's taking care of the children. Executor. There's a spendthrift provision which relates back to the trust, saying that you can't, a spendthrift provision says a beneficiary can't spend the trust before they've actually gotten it. And they can't say, hey, look, I'll give you, I'm getting 25% of this trust, why don't I give you 10% when I get it? You can't do that with a spendthrift provision. The whole reason is that this way, creditors can't come after that beneficiary and say, I'm going to take your the money you're getting in trust. Funeral arrangements can be listed in a will. The comment, again, is wills are not always read before funerals. So make sure that that's what we also do the disposition of remains form. The in terrorem clause is a no contest clause. It says if you contest the will, then whatever you're left under the will, you don't get it. This works great if they're a named beneficiary. Right? If you're intentionally writing someone out of the will and then they contest the will, this isn't going to help any. because they won't get anything under the will, and if they contest the will, then they still might get something. So you can have it, you can put it in, but think about it if they're, just be aware and let the client know that if you're purposely excluding a child, this is not going to make a difference of a potential contest. There's a paragraph here about wills not contractual. This goes to the question earlier about husband and wife. We sit husbands and wives separately when both are making a will. They both work with separate attorneys. The attorneys, for the most part, almost never talk to each other. In some cases, one attorney doesn't know who the attorney is for the other spouse. The only times recently that we've had them talk to each other, or the attorneys have asked for the contact information, has been when one spouse clearly knows more about the community property estate than the other spouse, and has a better idea of what property there is, what bank accounts, that sort of thing. And so to get that background information, it was helpful to do both. Our drafts use the old style attestation and then self-proving affidavit. These are, Texas law now allows for a combined version of this or a separate version of this. We've kept this separate because most states keep it separate, and so this way, if there's property in a different state, or there's any questions, or they die in a different state, there aren't any questions about why does this look weird. Any questions about the will? Yes?
Disinheritance of children. If one child is already deceased but both leave children, you have to name the grandchildren in both situations.
Yes. Because if you don't name the grandchildren, they still inherit per serbies. So you'd have to specifically say, I do not, so I'm not leaving anything to my child X or any of his descendants. So you might not have to specifically name them, but you'd have to specifically reference them. One other thing at the bottom here, prepared in the office of, please use your name, but you can feel free to use our address at Houston Volunteer Lawyers. And that's 1111 Bagby, this building, etc. It's all over the questionnaire and some of the other forms. All right, so the estate planning questionnaire finally opened. Again, this goes through some demographic information about family members, and then it has a couple pages about who receives your property, who takes care of children, who handles funeral arrangements, and then as you can see in parentheses, we've named the documents that are being discussed in the question. So let me skip to those documents. All right. So the medical power of attorney, what have I done? All right, Declaration of Guardian is the next one on my list. The Declaration of Guardian is a very powerful document, not because of the ability to say who is going to be your guardian if you need one, but rather the ability to say who will not be the guardian. This allows you to expressly disqualify people from being your guardian if you're incapacitated. Otherwise, it will automatically be assumed that your spouse, and if not your spouse, then adult children, parents, siblings, are presumptively the best people to be your guardians. This lets you say, look, I like my brother, but he can't be my guardian. This is really the only tool to say who can't be. Even if you name someone as your desired guardian, that doesn't mean the court will appoint them. The court's still going to do a background check and make sure that they don't have felony records, that they haven't been arrested for elder abuse or financial mismanagement or something like that. And if they are, and you say, I want my sister to be the guardian, but she's got this disqualifying criminal history, the court's still going to say, your sister doesn't work. So make sure that you realize that when you're going over this with your clients. Any questions about declaration of guardianship? All right. Yes?
If you had somebody specifically expressly disqualified as guardian,
yes,
is there still a possibility that a court would ignore that and appoint that person as a guardian?
No. So the court's going to use this in terms of, well, if the court knows of this document, the court will use this to say, we're going to skip that person. This is another one of those documents that is only relevant if the court knows about it, if someone else knows about it. So, but if someone knows about it, then the court will use this and say, hey, look, they said no to this person, we're going to listen to that. All right. Next on the list, medical power of attorney. The medical power of attorney goes through and allows you to designate someone to talk to to your doctors if you're incapacitated. It's specifically if you are incapacitated. If you are healthy, your agent is not relevant at all. But it really becomes necessary when you can't speak for yourself, if you're unconscious, if you're in a coma, that's when this is relevant. You can make limits on their decision-making authority. It's not required. You can name alternates. Realize that in a hospital situation, what's probably going to happen, they'll call the first person, right? And ask, can they speak to John? And if John doesn't answer, if he's not there, they'll call the first alternate and say, can I speak with Jane? And so even if they're listed second or third, if they're the first person to pick up the phone and it's an emergency from the hospital, they're the ones who are going to be making the decision. So it's often a question of, if your client's wavering on an alternate or wavering on who they want to be an alternate and saying, well, I guess Tom can be the third alternate. I mean, I'd rather it really be so-and-so, but he can be the third alternate. Maybe he shouldn't be on the page at all. And just be aware, be willing to discuss that with your client. All right. Any questions about the medical power of attorney? Yeah.
Michael, I'll add along those lines that I use cell phone numbers on those documents.
Yeah. So this is the one document that really asks for phone numbers, and it's important that it could be that you can put in their cell phone or their home numbers. You don't have to just put in one number. But it's really important that you're getting numbers that are going to get to the client. Oftentimes when you're interviewing your client, you'll ask for a phone number and then they'll have to go look it up in their phone. I've taken to stopping my clients from doing that and then just keeping a list of individuals and then giving them the list at the end so that my interview is a little bit smoother. I can say, make sure you get me the name, the addresses, and the phone numbers of these 5 people that you've mentioned, rather than having them stop every 3 or 4 minutes so that they can pull out their phone and try and look up a phone number, or say, well, let me call Tom and he'll give me his phone, and he'll give me his address. And I'm like, let's hold off on that. Let's finish the interview first, then you can do that. So one other thing to note is that this document and the directive to physicians reference each other, right? So the directive to physicians, which I'll talk about next, talks about what to do in an end-of-life situation, and it says refer to my agent under my medical power of attorney. So we've got a time block on this one when you're executing it so that you can write down what time you're executing it. And then when you go to execute the directive to physicians, you're writing down the time block on that so that you can show that the medical power of attorney existed before the directive to physicians existed. and so that one is already in existence when the other is signed. Make sense? All right, so the directive to physicians, no. It talks about two situations. It talks about the situation of when you are in a terminal condition expected to die within 6 months, even with life-sustaining treatment, what do you want? And so we've got 3 options here. The standard form has 2. The 3 options are to withhold life-sustaining treatment, to not withhold life-sustaining treatment, or to say, I'm punting, my doctor and my medical power of attorney can figure it out later. So that's what's here. That's followed by a second question about if you're in an irreversible condition and you cannot care for yourself without life-sustaining treatment. And then you've got the same 3 options. Withhold it, don't withhold it, or I'm punting the question, my agent and my doctor can figure it out later. Yes?
Why that third option, why bother to have the form? Because as long as you've appointed an agent, that's what would happen anyway.
Well, but this allows you to tell your doctor that these are my wishes, and it puts it in writing, and this way it could be that you've named your son or your spouse as your agent, and this way you might not want to have that discussion with them, although it's encouraged to do so. This way you've already memorialized your decisions. Yeah, Connie.
I could add that sometimes I have clients who are certain about what they want to do if they're in a terminal condition, but the definition of irreversible makes them a little less comfortable. And so sometimes they'll choose an option for terminal, but they don't want to choose an option for irreversible. They want the circumstances to be taken into consideration. So that this would allow for that circumstance.
The other thing to note is that we've often recommended drafting this and printing this with the blanks for them to initial, because I think after redrafting it for like every other client, it just became a lot easier for them to say, which one do you want? You, at the day of, you have them initial the one that they want, you have them cross off the 1 or 2 that they don't want. Rather than me picking out the right paragraph and then having to go back in and edit it and switch the paragraphs that they wanted. Make sense? Other questions? Yes?
Are these definitions of irreversible and terminal conditions, are they stated in the document?
Yes.
Definition?
Um, yeah. So, and that's provided to the client at the execution, but you feel free to familiarize yourself with it in advance, so that when they've got questions, which most of them will have questions about it. So, yeah.
And the crossed out and initial document is going to be okay and acceptable as the final document?
Yes. So the handwritten changes are much more of an issue on a typewritten will than they are in any of these other documents. It's only the will that has those exacting requirements. All right. The next document is the HIPAA release, which is just a general, broad HIPAA release saying, I give to any of my doctors permission to share protected health information with this person. The state of Texas has also promulgated a disclosure authorization of protected health information as a 1-page form. That's available to you on our portal. It makes a lot more sense when you're giving it to specific institutions rather than being the broad HIPAA release that's separate. It also asks you to like specify which institution this is for and that sort of thing, and so it's not as useful in a estate planning context as it is if you're, say, a litigator trying to get access to medical history at a specific institution. The last document to really discuss in detail is the disposition of remains. This allows you to start with your funeral and really spell that out. This does not become enforceable until the agent also signs it. But once the agent has also signed it, they become financially responsible for the funeral. So not every agent will jump up and say, oh, of course, I'll sign that. But know that it can be an issue. The form, if you've used this in the past, has changed slightly. The client signs it in front of a notary. The agent does not need to sign it in front of a notary. So there's a separate acknowledgement block that's a little different on the back end. You can have successor agents. I've often seen this document where the agents are not in the same country, same city, or even the same state as the testator. So those can be signed at a later date by the agents. They don't have to be there at the execution itself. And you can see client principal signs, and then you've got the notary block, and then you've got the acceptance and assumption by agent, and saying it where it notes that they become individually liable for the reasonable cost of the decedent's interment, from which they can seek reimbursement from the estate to a limit. Yes?
Is there some requirement that the testator actually agree to cremation in order? I've heard funeral directors say that to me.
Only, I think, if it's in writing, or if they've expressed, like, if there is no written anything saying that they want to be cremated versus buried, then it's sort of up in the air. Tony?
My practical experience is that a funeral home will require
Yes.
all of the family members to sign a document consenting to cremation. And so, if your client desires cremation, they should put their wishes in writing, and this is a perfect place to
And
do
then the
that.
family members will still have to sign, or will the funeral director?
Typically, yes, because funeral directors like to cover themselves before they cremate their body.
Thanks.
Is that the main purpose of this document, this disposition of remains, or
It's
are there other things?
it is one purpose. It's also very useful if you have a family where people might disagree as to who has the right to choose the type of service or interment that someone wants. So if you know that your client has children who have differing religious beliefs as to funerals, or there's family discord as to who might want to take charge of the body after the death, and this is a good tool.
And we actually had a client recently where this came up, and they didn't have one of these, and it was a common law marriage. And so the common law spouse wasn't able to make any of the decisions, and that it fell back on the decedent's family, parents, I think, who made those decisions, even though there had been a 10-year-long relationship in a common law marriage, that because there wasn't anything saying that this is a common law marriage, that spouse wasn't able to make those decisions or sign the paperwork with the funeral home. So it lets someone pull in a different relative. The other thing is, it says that instead of it being the parents or the children who decide, it's really this aunt who can make the call. So if there's a closer relative or someone or family member or friend who is more appropriate, it helps determine that. Yeah.
Does this document require that an agent sign it in order for it to become effective?
Yes. To an extent. So the individual's directions in terms of funeral decisions are that can be put in the special directions. That may be effective regardless, but in terms of the appointment of a specific agent to make those calls, that's not effective unless the agent also signs it. So if they put in here that they want to be cremated and signed it in front of a notary, that's effective. But if they wanted their son to be in charge of it and their son never signs it, that part's not effective. Yeah.
Has there ever been a case where someone prepaid for a funeral and either before or after that executed one of these and they were?
So that's why under special directions, they've already prepaid for a funeral. It should go into this document so that it's clear. Yeah.
And is the spouse going to be deemed to be the person who gets to make these decisions? If there's, okay, so that
If there's no document, there is a statutory guideline. There's a listing of those people who are given this responsibility under the statute. And it is what you would expect, those closest and then further out the family tree.
I thought there was another question.
Actually, it was the prepaid funeral.
Okay.
So if they're estranged from a spouse or haven't seen them in 10 or 15 years, which happens not infrequently in our client base, it's even more important to have that document. They may have never gotten around to the divorce.
All right, so I'm going to finish this up pretty quickly. We do have will execution ceremonies in both English and Spanish available. The professional services agreement is an engagement letter with your client. That's something that our grants require us to have for all of our clients. If you have your own engagement letter that you use with all of your clients, you're free to use those instead of our professional services agreement. Just give us a copy of it signed by the client. We include a sample instruction letter to clients detailing what they should and should not do with their documents. For example, do not put your will in a safety deposit box because then no one can get it. Or make sure that your agents have copies of your powers of attorney so that they can become effective agents. Those sorts of things. There is an initial/final disposition that we ask you to fill out. This basically says who you are, who the attorney is, and if you're representing them or if you will be drafting the documents but not able to be there on the final execution date or not. And then this lets us know and put in our system that link. And then at the bottom is the how many hours did this take you? What were the documents executed? We have a scanning cover sheet for when we do scan on the second date that I don't think I downloaded. Basically, that's available here. Basically, that scanning cover sheet says how many pages we expect it to scan, right? How long were each of your documents? How many pages should the scan have been? So that as soon as we finish the scan, we can look at the PDF and say, all right, this was a 20-page scan. It should have been 20 pages. We've got all the pages. We're good to go. Or there was a 20-page scan. We've got 19 pages. Hold off. Let's figure out what page got skipped. More often, it's we were expecting a 20-page scan. We got 25 pages. Hold off. Let's make sure we got all the pages. And that's often because our scanners are double-sided and we'll get a lot of backs of pages. So that's basically the documents. Like I said, Veronica and myself, the co-chairs, we're all available to review documents if you're uncomfortable with them, or if you've got questions or questions about how to draft something that you've never drafted before in terms of a choice of where the property should go. We're all available to be listening boards, drafting buddies, whatever you need. Any questions before I finish off? Yes.
Okay, if these are people who can't afford a will and they get a free will, what about when the time comes to probate? Can they get help
Their family can go through us. We have often done probates for family of deceased clients. We're definitely an option. On the other hand, you can also use this opportunity to talk about what sort of, do they have payable on death accounts? Do they have IRAs that have named beneficiaries, that sort of thing, so that you've got a sense of what's passing via the will and what is not. And that's always helpful and instructive for clients who, a lot of ours are not financially sophisticated. A lot of ours will not have retirement accounts or anything like that, but there are some who do. Or they have retirement accounts from organizations they worked with 20 years ago, and they may have named beneficiaries. The beneficiaries may have passed away as well. So it just helps to get the whole picture for the client. Yes?
Actually, quick question. Back to the memorandum, to the will.
Yes.
Is it the recommendation that the client does that they actually can write it, or can they type it up?
It's better if it's handwritten, I think, because then it's clearly this person's wishes as opposed to not, because those are typically not done with the same ceremonial formalities that you have with the rest of the will. So I think if you're telling your client about this and they decide that that's something that they'd like to have, that it should be handwritten. And then if they want to make huge changes, realize that that memoranda can't change anything that's in the will itself. So if they give the house to someone in the will, they can't say that the house really should go to someone else in the memoranda. It's really dealing with those small personal property items that didn't get disposed of in the will. Yes?
Once these documents get scanned, I guess that's after they're executed, they'll be scanned.
Yeah.
Who and when has access to the scanned documents?
So Houston volunteer lawyers will come back to the office. Executions are typically we typically do it on Wednesday. Typically by Monday, we've got all the documents uploaded to the portal. As an attorney, you'd be able to go in and say, view your closed cases, or depending on it, your open cases if we haven't closed it yet, and download those, that scanned file. The client can also contact us to get a copy, but often the client and you have a relationship and they'll contact you over us.
So we could then go to the portal and print copies and mail it to the client.
Right, exactly. But the other thing is that the client's left with the original so that they've assuredly got at least one copy of it. Other questions? Well, thank you all for volunteering. This is it's a huge service for our community. Like Tanya said earlier, we've got over 200 clients scheduled, so we're really excited. It's the first year at a new location, and so we're hoping that this all goes off smoothly, and we'll see you in just over a week.
Can I add with regard to copies, Alice has been working very hard to get a copier and paper donated and a technician donated for the day. Are we confirmed?
Yeah, confirmed.
Which firm is it that's going to do it?
KL Gates.
So KL Gates, the law firm, is going to do this for us for the day, so we would be able to send people home with paper copies as well as their originals.
Which we need to make sure that it's copied before it is stapled.
This sheet reminds you do not staple, the tables will remind you do not staple, everyone on our staff will remind you not to staple, and the letter to the client says don't staple. So
We should just check our staplers at the door.
yeah, right. We actually keep them. We don't have them near there. Yeah, but people do bring stuff ahead of time.
Thank you all very much.